Yeah, well, everyone on the list who no, I'm still saying
He's got one of the
Oh, that's not.
Welcome to Court TV on Crestview Community TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today you're watching Docket Day. Now, Docket Day, last year and in previous years, it was the biggest court date. Now we've added a court date with pretrial conference happening the week before Docket Day, so Docket Day has shrunk down and gotten somewhat smaller. However, you're still going to see defendants who maybe have been in court for the first time, maybe their appearance was waived at pretrial conference, which we spoke about in that video. But when someone's called to the podium, you're going to see, again, one of a few things can happen. They can enter a plea. At that point, the case will be over, and they'll get sentenced either today, live on Crestview Community TV, or they'll get sentenced in a sentencing hearing down the road on one of those miscellaneous dates that we'll talk about in another video. They could also ask to continue the case. At that point, it would get set to another cycle 6 weeks down the road. The last thing they could do is they could announce ready for trial. And that means, hey, we're ready, when we're going to send this case to a court date called jury review. And then from that point, the case will get sent to a jury trial. And I know that's what we all really, really love to see. Those obviously are rare. They don't happen a lot. But we all get excited when we hear that, ready for trial.
Court is now in session. The Honorable Terrence Ketchel presiding.
Please be seated. Hey, good morning. We're here on our criminal docket day for August. We begin with Mr. James.
JJ, we're ready for number 9.
Good morning. Good morning. Good morning. Would you announce the case? E3CF 864.
State of Florida versus Christopher Eli, or Christopher Eli.
Where we at? Ready for trial?
Ready for trial.
Your Honor, the state would leave this set for Thursday as a soft set. Your Honor, I understand that the defense wants to rush this for trial. The state is not trying to rush this for trial. I am attempting to get a rush on the FDLE results, and on Thursday I will report whether I'm able to get those done for trial.
So is that the only thing that's holding us up?
Yes, Your Honor. And this is a very new case, so FDOE was, I think this is a June arrest. And
I don't, first of all, just for the record, I don't mind people rushing trial if they're ready. Ready for trials. We're 5 months in from the arrest, but if you got something outside that's third party that we can't control, and we're doing everything we can, that may very well be a legitimate basis for continuing. So we'll continue. Let's bring it back on jury review on this Thursday, which is the 24th. 8/24. 9 a.m.
Yes, sir.
Thank you very much. Mr. Ray.
Morning, Your Honor.
Good morning.
Ethan Webb, I want to give both Your Honor, case 2023 CF 85, Your Honor. Prepared to enter a change of plea. I'd like to do that now, or we can pass.
Now?
Yes, Your Honor. At this time, Your Honor, I'm going to case before the court, the aforementioned case.
Do you have an extra copy of the agreement?
I do, I'm at Coach. I'll have the score sheet, sir.
Thank you. Score sheets, okay?
Yes, it is, Your Honor.
Okay, thank you. Would you please announce the plea agreement?
Yes, Your Honor. The agreed upon disposition, Your Honor, is Mr. Bodie will withdraw his previously entered plea of not guilty. He will enter a plea of no contest to the lesser included offense of unlawful use of two-way communication device to facilitate commission of a felony, count 1. He will enter a plea of no contest to count 3, unlawful use of a two-way communication device to facilitate commission of a felony. Both of those are third-degree felonies, punishable by up to 5 years of prison. It is agreed upon disposition, Your Honor, that as to both counts, adjudication of guilt will be withheld. As to count 1, Mr. Bodie will be sentenced to 2 years of
Count
community.
2 is null process?
That's correct, Your Honor.
Go ahead. It was that I just wanted to put it in. Go ahead.
Count 1 will be 2 years of community control, followed by 3 years of probation. Count 3 will be a consecutive term of 5 years of probation. Total length of supervision will be 10 years. It's agreed upon disposition, Your Honor, again, as to count 1 and 3, adjudication will be withheld. Pre-sentence report is waived. I've reviewed the Criminal Punishment Code guideline score sheets. There are no objections. Defendant will be required to pay the cost of supervision, which I believe to be $40 a month. Special condition he will successfully attend and complete sexual offender counseling.
Do we have that? I don't see that.
I believe.
Yes, Your Honor, it's checked actually further down in the agreement.
Okay, gotcha. Very good.
Your Honor, there are special conditions on page 2, which include no internet access except for work or school and/or as directed, monitored by the probation officer. There is no contact with minor children. Mr. Bodie is not under the influence of any drugs or alcohol. There is no restitution. I have reviewed the plea form with him. He has signed it. I have signed it. Mr. Brousseau has signed it. We would stipulate the factual basis in support of the plea, Your Honor. I do understand there are court costs and fines, and we would just respectfully request that the clerk direct us to the proper amount. We will pay it in due course.
And Your Honor, that is,
Does your plea agreement have a signature? Mine doesn't. I don't have signatures on it.
Your Honor, may I approach?
That's all right. I thought you might have given me the other one. That's all right.
I did the copy.
I'll switch it.
Thank you, Judge. Pardon me. Apologize.
That's all right.
and Your Honor, that is the state's agreement and within the guidelines.
Very good. Mr. Bodie, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor.
Okay. And what are the court costs?
Your Honor, I'm checking. It looks like there's going to be $515 in costs.
Take your time. I'm just going to go through the other stuff and then you can tell me. Okay, so Mr. Bodie, you heard your attorney state the terms of your plea agreement, and those same terms are contained in, it says sentence recommendation, it's actually a plea agreement. And my first question is, did you read this plea agreement
Yes, Your Honor.
And did you go over it in detail with your attorney?
Yes, Your Honor.
And you understand that by entering into this plea agreement here today, you're waiving some valuable legal rights, the most important of which is the right to go to a trial to force the state to prove their case beyond every reasonable doubt. Do you believe it's in your best interest to waive those rights as well as a few other rights that are contained in here in order to have a final resolution of this matter?
Yes, Your Honor.
And you have had all your legal questions answered by your attorney?
Yes, Your Honor.
Nobody threatened or coerced you to get you to enter into this plea or promised you anything that's not in the agreement?
That's correct, Your Honor.
Okay. Very good. Based upon that, the court will accept your plea agreement. The state has already announced its null pros of count 2. Count 1, the unlawful use of two-way communication device to facilitate the commission of a felony. That's a lesser included. You'll be sentenced to 2 years of community control, followed by 3 years of probation. Count 3, which is actually the same charge, you will have which will be consecutive to count 1, but it'll be an additional 5 years of regular probation. So a total of 10 years, 2 of which are community control. In addition, you've got cost of supervision, the requirements, sex offender requirements that are contained in the plea agreement and established by law. Any questions?
Respectfully, Your Honor, the only condition is just a sex offender or counseling. There is no designation on these charges, Your Honor.
Very good. Okay, very good. Thank you. Good luck. You do, even though you just entered into this plea agreement, you do have 30 days to appeal. Okay?
Yes, Your Honor.
Thank you.
And those costs are $515 only.
$515 is the cost.
Thank you.
Okay. Thank you, Mr. White.
Thank you, Your Honor. May I be excused, Your
You
Honor?
may. Thank you.
Thank you,
Appreciate
Judge.
it. Mr. Shaw.
Morning, Judge.
Good morning, Mr. Shaw.
First case I have is Chance Boyd. You, any chance?
Okay.
22 CF 2090. Judge, we left this on for clear continuance in hopes of resolving it. We haven't quite got there yet, so if we can put it on for the next pretrial date, we'd appreciate it.
Okay. Next pretrial is October 9th. Very good, 9 a.m. Broadnax is the next one, I think?
Yes, Judge. Unfortunately, same thing with Mr. Broadnax. I think we're going to have to take depositions in Mr. Broadnax's case, so we'd ask for October 9th as well.
Very good, we'll continue to October 9th.
Is your client here?
I did not see him, Judge. We waited because we weren't going to have him enter the plea today. John Edmund Holmes, Judge, 23 CF 454. Mr. Holmes. Judge.
If you come forward, if your name is called, don't hesitate to hold that.
Judge, on Mr. Holmes' case, there has been an offer of PTI made, provided the victims were in agreement. I think the state needs time to talk to the victim. So we anticipate that being resolved by PTI prior to October 9th.
Okay, you want to just do a full continuance or come back on?
Judge, I think a full continuance would be good, just to give me enough time to get the bill.
Okay, we'll continue to October 9th.
If we enter the plea, Judge, it'll fall off the dot, or excuse me, PTI.
Absolutely, yeah.
Thank you, Judge. Kevin King, Judge. Kevin. Judge, before the court is Kevin Cyrus King in 22 CF 00770F. We have entered into a plea and sentencing agreement that's signed by the state, myself, and Mr. King. May I approach with the guidelines now?
Mr. Shaw, that is what she just wanted.
And the sentencing guidelines, you're in agreement?
Yes.
Could you please announce the plea, Mr. Shaw?
I will, Judge. If you don't mind, I'll pull it up. I took a picture of it on the phone.
Take your time.
All right, Judge. At this time, Mr. King would withdraw his previously entered plea of not guilty, tender a plea of no contest, The terms are: count 1 would be to the amended charge of felony battery without great bodily harm. Count 2 would be as charged, which is interference with custody. Those would be 5 years probation concurrent, $515 court costs, $100 cost of prosecution, substance abuse evaluation, and any treatment within, substance abuse evaluation within 30 days. Any treatment would begin within 60. No contact with LJW. No unsupervised contact with any minors without a court order. Sex offender counseling. Early termination after 3 years if all conditions are met and there have been no violations. Counts 3 through 6 would be to the charge of contributing to the delinquency of a minor. They would be all 1 year probation concurrent with counts 1 and 2 and with each other. None of the counts would require a registration as an offender or a predator.
So it's a total of of the 5 years probation. The probation's
Correct.
There's 2 of them that are concurrent, and then 3 that are 1 year that are also concurrent.
Also concurrent with
State,
each
is
other.
this,
Yes, Your Honor, that's correct. Based on the totality of the circumstances, it's the appropriate disposition.
is this a downward departure?
No, it is not, Your Honor.
Okay.
Based on the score sheet that we provided the court, is adjusted for the charges they collected.
Mr. King, would you please raise your right hand, sir? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so you heard your attorney state the terms of your plea agreement,
Yes.
and I see those same terms are contained in the written plea and sentencing agreement.
Yes.
Put eyes on your signature, and it looks like you've signed the agreement.
Yes.
First question is, did you read this closely?
Yes.
And did you go over it in detail with your attorney to make sure you had all your legal questions answered about this plea agreement? Importantly, you're waiving some valuable legal rights. You heard me say it 100 times. Waiving the right to go to, most important is you're waiving the right to go to trial, force the state to prove their case beyond a reasonable doubt. You believe this plea agreement, first of all, do you understand you're waiving those rights?
Yes.
You believe it's in your best interest to do so?
Yes.
You haven't been threatened or promised anything that's not in this plea agreement?
That's good.
And you have had all your legal questions answered by your attorney. Based upon that, the court will accept your plea agreement. The court will sentence you as to the lesser included on count 1 and count 2 to 5 years probation. They will be served concurrent. And the other 3 charges contributing to the delinquency of a minor, those will all be given additional 1 years of probation. They will be served concurrent with each other and with the other 2. So it's a total, essentially, of 5 years of probation. In addition, you've got the other fees and circumstances, and importantly, there's no contact instructions that are contained in here. Obviously, with the minor, and no contact with the minor without court order. Tell me about that.
Your Honor, unless...
He cannot have any contact with minors without a court order.
Yes, Your Honor. If there is a minor that he routinely has contact with that wishes to approach the state or probation to request contact, then we would have to come back to the court to get that memorialized.
Okay. I'm just what's important, the reason why I'm questioning this is important, is that you need to be clear, and everybody else needs to be clear with you exactly what you're agreeing to here today. Because if you violate it, this thing will come undone, and somebody will be looking for a prison sentence.
Judge, the way the plea agreement was drafted, it indicates no contact with LJW.
That's correct.
And then no
contact with minors. No contact with minors without a court order.
Yeah, no unsupervised contact without a court order.
That's correct, Your Honor.
Okay, it says no unsupervised contact. Okay, very good.
Thank you.
I'm having a little hard time reading that.
Hey, it's my right.
No, that's good. So no unsupervised. Okay, you understand that?
Yes.
Okay. And that is, I mean, all I can say to you is take those issues real serious, because I promise you the state will. Okay? Okay. You do have 30 days to appeal this, and they just send you to. Thank you.
Judge, and lastly, I was asked to cover for Mr. Keith Kilpatrick. May we address that now?
You may. Hold on just a second.
It's Mr. Wire's case, Your Honor, just in case you're interested.
Got it?
Johanna Dwyer,
Dwyer.
22 CF 2711. My understanding, the state wanted to approach.
Yes, Your Honor, can we approach the bench
You
on
may.
this?
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Based upon the plea agreement, it is standard probation, not sex offender probation.
Thank you, Judge.
Thank you, Ms. Ward.
Thank you, Your Honor. Thank you, Mr. White.
Ms. Delbosa, excuse me. Sorry.
I can still do it.
Sure you've had people butcher that name.
Yes, it's Del Bosque, Your Honor, and everybody seems to.
Tell me, say it again.
Del Bosque?
Bill Boss.
Yes, sir.
Okay. Thank you.
You're welcome, Your Honor. I have Adrian Dismuke this morning. He has 2 cases, a VOP and a new charge, the 23 CF 0382.
Is there a waiver?
Yes, there is, Your Honor.
Okay.
And a 19 CF 1387. We've worked something out with the state, Your Honor. Can we leave this set for Thursday for a plea?
Sure.
And then I'm here, Your Honor, for Tom McGuire on Chanteau House.
Hold on a second. What's the next case?
Chanteau House for Tom McGuire.
Oh, for my wife.
It's 23 CF 998.
Hold on. Very good.
And I believe the state has an announcement in this case, Your Honor.
The state will be no crossing this case at this time.
Very good. Court will note the null pros of 23 CF 998.
Thank you, Your Honor. That's all I have. Thank you. Excuse me.
Thank you very much.
Thank you.
Ms. Merrifield.
Good morning, Your Honor.
Good morning.
Randy Merrifield on behalf of Jennifer Higginbotham. Ms. Higginbotham is present and approaching judge in 23 CF 1235. And Judge, we've reached an agreement if I may approach.
You may.
Swear
Thank you.
sheet's behind. Thank you.
Defense okay with the score sheet?
Yes, Your Honor. And in 23 CF 1235, Ms. Higginbotham will be withdrawing her previously entered not guilty plea, entering a no contest plea as charged. Count 1, which is felony driving on a suspended license, would result in a withhold of adjudication, $515 in court cost, and 10 days in the Okaloosa County Jail per statute with credit for all time served. To begin that sentence on September the 19th, and count 2, the misdemeanor, would be dismissed. And Judge, we would ask for 90 days for her to make payment of court cost.
Very good. State?
That sounds correct, Judge. I might have missed it, but I also think we're asking the court to allow this defendant to serve the 10 days on the weekends.
And just to clarify, Judge, we did originally agree to do weekend service. We have made arrangements for children, so beginning September the 19th, she will be able to serve the full 10 days.
Okay.
Thank you, Mr.
Very good. Let me just ask you to put in there payment in 90 days. so
Absolutely, Judge Manfred.
Make sure it's your email.
Thank you.
Ma'am, would you please raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
Okay. You heard your attorney state the terms of the plea agreement.
Yes, sir.
Yeah. And those same terms are in the written plea agreement that you've signed. My first question is you heard me say, ask other people, did you read this closely?
Yes, sir, I did.
And did you go over it in detail with your attorney and make sure you had all your legal questions answered?
Yes, sir.
You understand you're waiving the right to a trial, a jury trial, you have that right. You're waiving that right here today.
Yes, sir.
And this will be a final adjudication of your case.
Yes, sir.
You have had all your legal questions answered, and you believe this is in your best interest.
I do.
Okay. Based upon that testimony, the court will accept this plea agreement. State's an agreement, right?
We are.
As to count one, there'll be a withhold of adjudication, fees and costs that's contained in the plea agreement. You're sentenced to 10 days in the Okaloosa County Jail. You will get credit for time served. You will not have to begin your sentence until September 19th, 2023, so you must report on that day. Count two will be dismissed as part of this plea agreement, and any court costs are payable within 90 days after your release from jail. Okay, any questions?
Yes, sir. No, sir.
Okay. Thank you very much.
Is there a time on that report day for 9/19?
Good question. What time?
She'll report by 5 p.m.
Is that okay? That's the jail. Asking probation. Okay, 5 p.m. That's
Thank you, Judge. That's all I have this morning.
30 days.
Ma'am, you do have a right to appeal this in the next 30 days. So is that your only case? Mr.
It was, Judge. Thank you.
Very good. Mr. Mitkevicius. Mitkevicius.
Yeah.
I'm getting close.
Good morning, Your Honor.
Good morning. Do we need to swear in the interpreter?
Do you agree to accurately interpret from English to Spanish and Spanish to English the matters brought before the court today, so help you God?
I do.
Counsel.
Joseph McKevich is the record on behalf of Mr. Cordero Turcios. It's case number 23CF1352. Your Honor, I was able to get the video footage in the case the state sent it over that day. I've reviewed it, missing a couple things that I think they could probably get me before trial, but I do maintain we're ready for trial. I believe the state was going to ask for a continuance.
Your Honor, just so you're aware of what's been going on in the case, Mr. McKevich looks like he got the discovery or what we sent over on the 15th. On the 16th, he came to court and announced he was ready for trial. This is a brand new case, and the state does have the authorization from the victim to get the medical records, which are needed for trial, but we have not received them back pursuant to a subpoena yet. We are attempting to get a rush on that, so if we could leave this offset, and I will attempt to get a rush on that, so that we
So
can...
you're saying if you can get the medical records by Thursday, which is jury review, we're ready to go.
Yes, Your Honor, we'll be ready to go.
Okay? So we'll schedule it for jury review, which is this Thursday, 8/24, and we'll hold it as a trial or continue based upon whether they can get the court documents. So they can get those, not the court, the medical documents, if they can get those, we'll go from there.
Okay, that sounds good to me, Your Honor.
Thank you. See you
I have
Thursday.
nothing further. I'll see you
Yes,
on
sir. Have a
Thursday.
good day. Ms. Condon. That's true. Good
This is William Hanson, 23 CF 223. The written plea has been signed, and we just need to set it for control.
Speak to me that mic for me.
The written plea has been signed, and we just need to set it for control date for the entry into the PTI.
Okay. When do we want to do that?
Judge, I think this is, if you could set it out for one cycle continuance. I mean, the PTI is currently with probation. It's just going to fall off your docket at this time.
Okay.
So,
Is that good, Ms. Conley?
Yes, thank you.
Okay. So we'll just continue this until October 9th. Okay. Thank you very much. Mr. Swiatek.
I believe he's talking with him, Mitch.
Mr. Durrell.
Morning, Your Honor.
Good morning.
Hey, police the court, Dustin Burrell. Your Honor, my first case today is Mr. Franklin Applewhite. Your Honor, I would just request to continue Mr. Applewhite. I spoke with him this past week. He's trying to give me some more documentation I'd like to share with the state. I do anticipate a plea next cycle, though.
State.
Just a second. Your Honor, the state doesn't oppose a continuance. However, I will announce on the record, if there is not a plea next cycle, the state will withdraw the currently open offer.
Understood. Very good. We'll continue to October 9th, 9 a.m., in which case Mr. Applewhite will come back with not in shorts. Please. I know it's hot outside.
Next is Ms. Catherine Booker. Ms. Booker is present, Your Honor. Your Honor, I would request a continuance on Ms. Booker as well. I'm trying to set up a conference with Ms. Sharpless and Ms. Sandler to discuss Ms. Booker's case. Hopefully we can get a resolution once we have that meeting.
Your Honor, that is accurate, and the state does not oppose a continuance.
Okay. We'll continue it until October 9th, 9 a.m. If you all get a resolution, you can get it on one of the earlier miscellaneous dockets.
Yes, Your Honor.
Okay. But if we don't get a resolution, or is this the last continuance, are we ready to go next time? Because we're over a year into it.
I've gotten all the videos. I believe we should be ready at that point.
State?
Your Honor, I think that would be fine.
Okay. Would the minutes please reflect this will be the last continuance?
Yes, sir.
Okay, thank you.
Your Honor, next is Mr. Chad Crane. We do have a waiver for Mr. Crane. This is a PTI. We just got all the signatures last week, Your Honor, and I apologize. I didn't get the fully signed out to him in probation to get them in touch until last Friday. So if we could set him for 10-9, that should fall off your docket as soon as he gets in contact with Ms. Ferris.
Very good. We'll continue to October 9 in anticipation of the PTI.
And last for me, Your Honor, is Mr. Frank Dixon. Similar to Ms. Booker, I'm trying to get a sit-down with Ms. Sandler and Ms. Sharpless to discuss possible resolution for all of Mr. Dixon's charges. We may have one last continuance on this.
And a
I'll be
similar
ready to go next
question
cycle.
for the state, last.
I think that's fine, Your Honor. I don't think we have anything else up to do.
Very good. So we'll continue it until October 9th, and the minutes will reflect this will be the last continuance.
Thank you very much, Your Honor.
Thank you.
I
Have a
believe
good
that's
day.
all I have.
Thank you.
Thank you.
Okay. Mr. Keach?
Marcia, no.
Good morning, Your Honor.
Good morning.
We are here in the state of Florida with Mauricia Knox. She has 3 cases on the docket, one including a violation of probation. I think my understanding from last week is that we were placed back on the docket to try to figure out and coordinate the VOP hearing. But after speaking with my client and reviewing the file, we're prepared to admit to the violation of probation. She does have a 6-month suspended sentence and has ample amount of time in that. So if the court's inclined to take it orally, we can do that now in 20 CF 2949. If not, I can step back and draft it in the plea agreement.
If you wouldn't mind. We're
Okay,
just trying
perfect.
to keep it papered. But
Yes, sir.
We'll
And
keep
then
it around.
And then we'll have to schedule her other 2 cases for a later date, for control date.
Okay.
All right.
Fine.
We're going to get this drafted and do so. Okay.
Right this way.
Step out.
That's your only case, right, Mr. Keach? Yeah.
Yes, sir.
Mr. Switek back yet?
No, I saw him, he's out there talking to another client.
Mr. Noakes? Just wave at me if we get any of the privates. Let's go ahead and do ORCC.
Okay.
So, Mr. Hart. Come on. Sure.
If I can start with Vera Carroll, she's number 34 on the docket. Judge, there's a waiver of appearance in her case. I would ask to continue this to the 10-11, the 10-9 docket.
Out of custody is October 9th.
Judge, that should be a plea that cycle. The next one that I have is Jonathan Cook. Your Honor, I've been advised by a message left over the weekend that he was booked into the Santa Rosa County Jail yesterday, which is why he's not present today. It had been my intent to continue this case. We recently received a canine video, which was pertinent. I have not had the opportunity to review that. He has made efforts to come see me. I just haven't been able to do that just due to court and whatnot. So I'd ask to continue to the 10-9 docket, Judge. I'm fine with that.
You want to do it the 10-11, anticipating he's in custody? Or will he get out?
His relative was attempting to bond him out, Judge.
Okay, so we'll do it October 9th, and if for some reason he's in county jail, it'll be moved on.
Well, Your
I'm
Honor,
sorry.
this case is older, and I did make Mr. Harper an offer I thought Mr. Cook would take today. I understand he's not here, he's in jail.
Have you
So-
gone over the offer with him,
I
Mr.
don't
Harper?
think so,
You haven't
Your
even met
No,
him.
Judge, the offer was this weekend, and although I had spoken to him this weekend, I didn't know he was going to be arrested.
Okay, so let's do it this way. First of all, we'll announce the last continuance.
That's fine, Judge.
So if the minutes would reflect that. And if you can get up with him, even though he's in the other jail, if you can get up with him and accept the plea agreement, get it on one of the miscellaneous docs, we'll get it done, get it resolved.
Yes, sir. If I
Okay?
can do that.
Is that okay?
Yes, that's fine.
The next one, Judge, is Stacy Crowley, number 36 on the docket. She is present. She's before the court on 22 CF 656. Judge, on this case, I'd also ask to set it for 10-9. This will be either a plea or a trial next cycle. This will come to a resolution that cycle, Judge.
Okay. Stay okay with the last
Your Honor,
continuance?
I believe the last continuance should be appropriate.
Very good. The court will continue this to October 9th at 9 a.m. With the minutes reflect, please, that should be the last continuance as well.
The next out of custody judge is Sherry Dorgan. There's a waiver of appearance in her case. She's number 40 on the docket.
Okay.
With respect to Ms. Dorgan, I would ask to continue this to 10-9. I'm waiting on some reciprocal discovery from her, some phone records to provide to the state. Hopefully when the state receives that, we should be able to resolve this case that cycle. But I'm fine with if the court would want a last clear a trial that cycle, because depots have been concluded, it's all done.
Your Honor, I believe the last continuance would be appropriate, and Mr. Harper, I do need those records from your client, so I need them before the next pretrial.
Yes, the minutes would reflect last continuance.
The next case I have is Jeremy Knox, Judge. That is number 47 on the docket, 22 CF 47. Judge, there's a waiver in this case as well. I've spoken with the state. I think we're going to do a telephone deposition of the co-defendant in this case. That should be the only outstanding deposition that's remaining, and that should conclude this matter. We'll leave it set for a plea or a trial next cycle.
October 9th, last continuance.
The next one, Judge, is Marlon Marshall. I don't see him at this moment, Judge. If we can pass to see if he does show up.
Okay.
The next one that I have is Logan McPherson. This should be a plea. I apologize. There's a waiver in his case, Judge, but this is a plea to a misdemeanor in absentia. If I may approach. It's just a misdemeanor and just court costs, Judge.
Okay.
And but for Mr. Marshall, those are all my out of custody. If I can proceed forward my in custody if the court would want, or if they want to. It looks like this is Sarah Browder, Judge, number 33 on the docket.
Hold on just a second. Okay, go ahead.
She is before the court on 22 CF 2882. The state and I have been making counteroffers to one another, and I think we're actually closer to a resolution. If we can set this on the next miscellaneous court date, I think we can come to a conclusion on that date.
Are you, what about jury review? I know that's only 3 days away, but is that a possibility that
we can leave it set for jury review, Judge.
Okay.
That's the
I'll list it as a plea to continue non-anticipating trial.
Yes, sir.
Yes, Your Honor.
Thank you. Forcaeus?
Judge, this is Rebecca Farakis. She is number 42 on the docket. She's before the court on 22 CF 2327, 23 CF 1067, and 23 CF 1351. Judge, I've spoken with the state on this, that I think that at this point we probably need to do depositions of the newest charge, and I would ask to continue this to 10-11 so I can get those depots set, and hopefully we'll be able to resolve the next cycle.
State,
No objection.
continue this matter till 10-11.
Okay, thank you, Judge.
Thank you.
Judge, next is going to be William Bentley.
What about Tricia Davis, number 38?
Judge, it's come to my attention that Ms. Davis is being private counsel.
Okay.
I didn't see a notice of appearance either, but there have been some. Can I approach on Ms. Davis?
Yeah, he briefed me ahead of time.
What's that?
He briefed me ahead of time about that.
Okay, but he,
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and
very good. So this is a plea or trial, or are we ready for trial?
This is a plea or trial.
Okay. Jury review 824.
824, this Thursday.
Mr. Swiatek?
He just walked,
He's
he's going
walked
back
back
to
out,
talk to his client.
okay.
Gus Curley?
Judge, this is Gus Curley. He's before the court on 22 CF 1028, 22 CF 1532, 22 CF 1542, and 23 CF 557. Judge, I've contacted Lieutenant Oliver at the county jail. She's acknowledged that she has some items that are of value to his defense, namely some correspondence from the victim in this matter. So I'm asking to leave this matter set for trial. I will hopefully get that before Thursday, but regardless, we're not continuing it. We're asking to leave it set for trial.
Okay.
Stage ready for trial as well, Judge.
Very good. We'll come back on jury review 8/24, 9 a.m.
This Thursday, okay?
He needs to talk to him first. Right this way, sir.
Judge, the next one is Cornelius Donaldson. Judge, this is 22 CF 1617. Judge, is there any way to approach on this?
Yes.
Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street.
Thursday for a plea or consent.
Judge, next is, I believe, Eric Edwards, 21 CF 1210 and 21 CF 2883. Your Honor, likewise, can we approach on this matter?
Sure.
They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at DaceTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Review this Thursday, 8/24, for a plea or continuance.
Judge, this is Mr. Fuggerson, number 43 on the docket, 23 CF 445. If I may have just one particular moment, Judge. Judge, I've explained to Mr. Fuggerson that the offer will be revoked today if he does not accept it. I think that based on the circumstances in this case, Mr. Fuggerson would like to do the depositions of the victim and the witnesses. So I'd ask to continue this 10-11 pretrial. And again, the state's advised me that they'll be revoking the offer at this point.
One moment. That's correct, Judge. We're revoking our offer at this time.
Very good.
Yeah, we'll talk. Judge, if we can
Mr.
set...
Parkerson, you do understand the offer is being revoked here today? You understand that?
Do you understand that 27 months DOC is being revoked today?
The state made an offer, and after this hearing, when you walk off, the state's revoking it. Are you clear about that? I just want to make sure. I don't want to, hey, I thought we had an offer out there.
Just answer the judge, you understand?
Oh, yeah, sir. Yes.
You're clear?
Yes, sir.
Okay, very good.
Right this way, sir.
How long are we continuing to, Judge?
I'll come to a full cycle, but will this be the last continuance on this?
Yes, Judge, I think that's appropriate. They're continuing to conduct a deposition of someone who the state doesn't plan on calling a trial.
Okay. We'll know the last continuance. Okay.
Right this way, sir.
Thank you.
Hudson?
Would you please announce?
Judge Rudy Harbour on behalf of Mr. Hudson, 23 CF 855, to alleviate some of the concerns we had both in meeting with him as well as last court date. I think I'm going to be asking for an evaluation in this matter. So I'd ask to set this for the 10/11 court date to allow that to occur.
Very good. The court will continue this matter till 10/11.
They still have me on the picture.
I don't want you talking about anything.
James Allen, or Allen James.
Mr. Harper, did you get my email about this case?
Yes. Just one moment, Judge. Judge, on this case, Mr. Allen, 23 CF 836, the state and I are unable to come to an agreement. We'd hope to do that. I would ask to continue this to the 10/11 cycle. I'll do the deposition of the victim in this matter, and hopefully that will address some of the concerns. And I'm fine with leaving this for a plea or trial next cycle. This is Allen James. Sorry, I keep saying James Allen. I apologize.
State?
That's fine, Judge.
Very good. The court will continue this matter until the next cycle, October 11th at 9 a.m. for plea or trial. This will be the last continuance. Man.
Michael Jenkins.
Judge, this is Michael Jenkins. He's before the court on 22 CF 2308 and 23 CF 314. The court may recall at the last hearing that I announced that I would be adopting Mr. Jenkins' pro se motion to suppress. We had asked to see if we could set this for a hearing date during the jury trial week, if there are availability. It's my understanding that the jury trial week is pretty much packed due to prospective trials. I will be filing an amended motion to suppress on that case because I think it needs to be cleaned up just a little bit. I can get that filed within the week, but I believe the state's going to...
I'm sorry.
I think the state would like some time to review that.
So what I would suggest, refile it, get it to the state. When you all are ready to set it, call my office because we'll be setting it through the JA in the afternoon of the miscellaneous document.
Would it be permissible to move this to the next miscellaneous just to keep a tighter grip on it?
We can, but I mean, it's in the morning, so that won't really help us really. if you need to put it on for whatever reason, then we'll get it on. We got to get that done, if you're telling me that's where we're going with it.
Yes, sir.
It won't help to get a status on a miscellaneous earlier.
I'll
I'm ready, we'll try and get it on as soon as we can, once you get it refiled.
Yes, sir.
I mean, that's not an issue. But as far as just status, let's bring it back on a pretrial unless there's a reason.
So if we can get this on the next pretrial, in the interim, I'll coordinate with your JA to get the motion suppressed file.
Very good.
Set.
So we'll continue to 10:11.
Thank you, sir. Mr. Creech is ready with Marcia and Knox, I believe. That's all we're doing.
Judge, if I just may have a minute for her to execute the plea form.
Sure. So we've got the VOP case. The other two cases are continued till October 11th, is that correct?
On Ms. Knox?
Ms. Knox.
Correct. Now, if we want to place them on the October 11th, since she's still incarcerated, obviously, if she bonds out, she'd still show up on October 11th, even if she's... We'll deal with it. May I approach with the terms?
Sure. Thank you.
Judge, Ms. Knox is here before the court in 20 CF 2949. It's a violation of probation. There's a 6-month suspended sentence that we're asking the court to impose as she admits the violation of probation, which is the cap or the maximum she could receive. She has been incarcerated since May of 2022, so she has adequate time in.
State?
Your Honor, this is Mr. Rogers' case. However, I have spoken with Mr. Rogers, and it does appear that she does have a 6-month suspended sentence, so that's the cap on incarceration, Your Honor, for this case, this violation.
So are we, just so we get all the details, standard fees and costs?
Correct.
Okay.
I'm sorry.
That's all right.
I never read into that.
All right, Ms. Knox, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
And you heard your attorney state the terms, and the state attorney as well.
Yes, sir.
That is that your understanding with the plea agreement? You got a 6-month suspended sentence. You've already been in jail 6 months, so you get credit for all time served. It will allow you to get out, but you are waiving the right to go to a trial to contest this and giving us some other valuable legal rights. Just want to make sure you understand that you've gone over it with your attorney and made sure that you believe this is in your best interest to do this.
Yes, sir.
Okay. You had all your legal questions answered? Very good. Okay. Based upon that, the court will accept your plea and on the violation, the admission of the violation of probation, and you will the 6-month suspended sentence. That's what the court's sentencing you to 6 months in Okaloosa County Jail. You will get credit for all time served, and it actually says on the plea form that you've been in jail since May 20th, 22, which would allow you to be able to get out immediately, and then the fees and costs that are contained will just go to a civil lien. Okay? You want to give her a certain amount of time if she's getting out now before it goes to a lien and might affect her driver's license? State?
I don't have a problem
Why
with that.
don't we give her 6, I'm going to give you 6 months to pay these things, because sometimes it affects whether you can get a driver's license and all that.
Yes, sir.
So, give you a little more time. Thank you. Okay, thank you, ma'am. Mr. Switek, you want to?
And then the other cases are on October 11th.
Yes, the other cases are continued to October 11th, your other two cases, okay? Thank you. Mr. Schweigel.
Good morning.
Good morning.
Revoke the term on her.
First case I have is Christopher Bartle. It's 2021 CF 2004.
Hold on, sir, let him come out. You may proceed, Mr. Schweigel.
Your Honor, if I may approach, I have a plea agreement that's been executed by everybody.
You may. You may.
Almost, Mr. Bartle would like to say. I also have the score sheet that was prepared and looked at it.
Very good, thank you. Mr. Switek, would you please announce the plea agreement?
Your Honor, in case 2021 CF 2004, Mr. Bartle withdrawn his previously entered plea of not guilty and pleaded no contest to counts 1 and 2 of the information. Count 3 would be null cause. You would be adjudicated guilty of 1 and 2, and serve 28 months incarceration in the Florida Department of Corrections, with credit for all time served. On count 1, that would be followed by 32 months sex offender probation, with all standard sex offender conditions, as outlined in paragraph 5B. In addition, no internet access, via GPS monitor, sex offender designation, fines and costs and fees of $883.48. As to count 2, there would be 60 months sex offender probation, consecutive to count 1, with all standard conditions as I mentioned. And that is the term of the agreement.
And count 3 will be null process by the state.
That's correct, Your Honor. That would be double jeopardy, and the rest is our agreement, and it is within the guidelines for sale.
And count 2 is lesser included?
It's an attempted, Your Honor.
I'm sorry?
It's an attempt, so it's,
Okay.
yes, it is lesser included.
Okay, just want to make sure.
It's the same
Proper.
statute, Your Honor.
Okay. Mr. Barber, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Sir.
So, Mr. Barber, you heard your attorney state the terms of your plea agreement, and I see those same terms are contained in the written plea agreement that you've signed. First question is, did you read this closely?
You could read it because we were in the attorney interview room, but I did explain it line by line.
You did?
I understand the conditions, Your Honor.
Okay. So it's been explained to you in detail? And have you had a chance, yes? This is being recorded, yes?
Yes, sir.
Actually, these things sound very rote and everything, but they're actually these are very important, this discussion. Because I want to make sure that you're entering into this with knowledge, freely and voluntarily, okay?
I am.
Okay. So, so you've gone over it in detail with your attorney, had all your legal questions answered?
Yes, sir.
And you understand that by entering into this plea agreement here today, that you're waiving a number of legal rights, many of which are contained in this agreement?
Yeah.
Have you gone over those legal rights that you're waiving? The biggest one is the right to go to a trial and to force the state to prove their case beyond a reasonable doubt. Got a good attorney, fight this thing. You're waiving that right, do you understand that?
Yeah.
And you're doing so freely and voluntarily?
Yes.
Nobody threatened or coerced you to get you to enter into this plea?
No, sir.
Did anybody promise you anything that's not in this plea agreement? Do you have any further questions?
No, sir.
Okay, very good. Based upon that testimony, the court will accept your plea. And as to count one, there'll be adjudication of guilt on both counts. As to count one, you'll be sentenced to 28 months incarceration in the Florida Department of Corrections. You will get credit for all time served. That will be followed by 32 months sex offender probation with all standard conditions that are contained in the plea agreement, and specifically in 5B, the additional conditions, statutory conditions. No internet, GPS monitor, sex offender designation and costs, and the fees that are contained in the agreement, 883.48. As to count two, there's 60-month sex offender probation, consecutive, so it'll be added on to count one. So it'll be a total of 92 months of sex offender probation, again with all the standard conditions below in 5B, and no internet access, GPS monitor. You do have one additional thing. You do have the right 30 days to appeal this sentence to the court based on this agreement. Okay? Any questions? Mr. Switek, anything?
I've never done this before, but could the court give a recommendation that we serve the remainder of the sentence at the Okaloosa County Jail?
There's a reason why the court never makes those recommendations. It's a polite way of saying no. That's not the court's purview. Thank you.
I missed if you gave a vote, right?
I'm sorry?
I missed if you gave us a vote, right? I missed it.
I did.
Okay, right, so we can we slide Mr. Medina in with the interpreter, please?
Sure.
Your Honor, this is Luis Arriaga for the court. Mr. Arriaga is 23 CF 1122.
Hold on just a second. Let me get
I'm
this.
sorry, Your Honor, I didn't have the docket number handy.
I'll get it. I'll get it. Okay, I've got it.
Your Honor, we have two issues to discuss.
Did you give the case number on this one?
I'm sorry, Your Honor, 23 CF 1122.
Okay, thank you.
Your Honor, I received some information that the state might be willing to dismiss the case. Does the state have any information on that?
Yes, Your Honor, at this time the state will be entering a dismissal of this case.
So the state is announcing null process, dismissal of the case.
Yes.
Thank you, Your Honor. Thank you, ma'am.
Okay. Thank you.
Right, so, sir.
That is what I have, Your Honor.
Thank you, ma'am.
Thank you, sir.
Appreciate your help. Sorry, Mr. Switek. I need to interrupt your
Thank you, Your Honor.
thing.
That's all right, Your Honor.
Buchanan.
The more time I spend in this courtroom, the better my day is.
I'm glad you feel that way, Mr. Switek.
Your Honor, my next case is Bernard Buchanan. It's 23 CF 25. Mr. Buchanan is present. And we're ready for trial on this case.
Your Honor, can we approach the bench on this case?
Sure.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Third on Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Bar of the court will announce one last.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa.
9 a.m. Last continued. Thank you.
Madam Clerk, can you tell me when docket day trial is for that?
It's like, doc, you want me to get docket day on it? I'll give it to you. So the docket day would be October 16th, and the first week of the trials would be October 23rd. And of course, that's 2 weeks back to back.
Thank you, Your Honor.
Thank you. Donald Holder, I guess your last one.
Yes, Your Honor.
Would you announce, Mr. Swiker?
Your Honor, Mr. Holder has chosen to, in case 22 CF 1875, to do a plea to the bench. I have an agreement reflecting that. I will execute and I will bring it to the bench. Sign that again. May I approach right now?
You may. Thank you. Is there a guideline score sheet on this case?
Your Honor, we generally do file those at sentencing, but I can, unless...
I just want to do it to engage in the colloquy. What's the minimum guidelines? That's all I need to know.
Yes, Your Honor, it's a level 7 offense, so it's going to be 56 points with a maximum of 5 years.
So that's a maximum of 5 years.
That's correct.
What's the minimum guidelines?
It's going to be 21 months, Your Honor.
21 months, and that's for both of the charges.
Your Honor, there's only that one count. The second one would be duplicitous and be double jeopardy.
Okay, so we're just talking about count one.
That's correct, Your Honor.
So it's 21 months as minimum guidelines. Of course, it's a 5-year max.
And Your Honor, as the court is inquiring, I'd also point out that that charge will require sex offender designation.
Okay. So that sex offender designation is going to be, would be applied at this point in the family. In other words, that's automatic is what you're saying.
Your Honor, generally it's generally imposed at sentencing.
I understand it's imposed as
Yes, Your Honor,
sentencing.
it is automatic.
But will I have any discretion? Are they going to be asking me not to impose that? And that's why I'm being clear, because I'm about ready to tell him this. My understanding is it's automatic. I'm going to tell him, you understand, it's automatic.
That's correct, Your Honor. The court has no discretion based on the charge that he's pleading to. That is correct.
Okay. Do you agree, Mr. Swite? I just want to make sure we're all, I want him to understand what he's doing by entering this plea to the bench. Because this has got a lot more moving parts than a normal plea.
Right. Ms. Boswell is correct.
Okay. Very good. Mr. Buchanan, would you, excuse me, Mr. Holder, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, I do.
Okay. So you heard your attorney and state attorney as well. Your attorney stated you wish to make a plea to the bench, which is contained in the written plea agreement. And as a part of that plea to the charge, to the single count charge, is that it would require the court to automatically have a sex offender designation. Do you understand that, first of all? No?
Yes.
Okay. Yeah, just so we understand what's going on here in this conversation. This is an important conversation, okay? Because one thing that you have a right to do when you're entering into this plea is that, one, that you understand what it is, and that's what I'm asking you some questions. Make sure you understand what you're walking into, okay? Secondly, I want to make sure you're doing it freely and voluntarily, after knowledge, after discussion with your attorney. That's the basis of these questions, okay? And this is a little bit different. This is a different than a, quote unquote, a normal plea. What you see generally, normally we actually have the agreement with regards to the sentencing.
Yes.
In this case, there's no agreement as to the sentencing. So the first part of the equation, you're pleading
No contest.
well, there's not an adjudication of guilt at this point. So, well, are you agreeing? Is there an adjudication of guilt at this point? I mean, there's not.
That wouldn't occur until sentencing.
At the sentencing. But that's a part of what this plea agreement is.
That's the court's.
That's not discretionary. And the maximum prison term for this matter.
I've actually.
Your Honor, our understanding is if the court chooses to impose a solely probationary sentence, then
He could
Oh.
withhold. Okay. That's why I wanted to make sure we had clarity on. So, the maximum sentence that the court could sentence you to is 5 years in DOC, right? You understand that?
Yes.
And the minimum guidelines would be 21 months DOC.
Yes.
I'm sure your attorney, I'm asking you, has your attorney explained that to you? You understand what minimum guidelines are?
Yes.
If you go below that, you've got to be a downward departure. That's a whole statutory, the whole followed by law, very detailed. The court just doesn't have open discretion. I can do what I want. So, well, you're the judge. You can do what you want.
Right.
No, I can't. I have constraints with which my sentencing is allowed. One is there's a maximum. Two, there's a minimum. And the minimum guidelines put a further fence on my sentencing.
Yes.
Do you understand all that?
Yes, sir.
And I did explain to Mr. Holder what downward departure is and what has to be proven.
Correct.
And it's the discretion of the court. And it's a two-part equation.
Yeah.
And we would move for that.
And the two-part equation being, what are you referring to? I think I do, but say.
It has to be the right case. You have to decide this is the right case for the court
Right.
to do that. Then there's A through L, I believe, of the different criteria he has to fit into, which most likely it would be that it was an isolated incident for which he's shown remorse.
So, in jumping in to what your attorney is telling, which is absolutely correct.
Yes.
My two-step is that even, so you have eligibility for a downward departure.
Yes, sir.
If you don't get the eligibility, I have no discretion. I can't go below 21 months. But even if there's eligibility, then there's total discretion on the court. That is something that I have total discretion. I can determine to go below the guideline or above the guideline
Yes,
or
sir.
the max.
Yes,
I
sir.
got all that.
Right.
You understand? I'm going to listen to everything. Your attorney's going to get a chance. We're going to have a full-blown hearing on this. Not like a trial.
Yes.
No jury. But there will be a full-blown hearing. He's going to be, giving me all the arguments through testimony, etc.
Yes, sir.
Why you should, whatever he's arguing.
Yes, sir.
And the state court going to be arguing something different.
Correct.
Just as vehemently, I'm sure, in their past. So, I just want to make sure you understand all that.
Yes,
You've
sir.
got the fees and costs that are contained in this, no matter what. Okay? So you're aware of all this. You understand that by entering into this plea, you're waiving the right to go to a trial and to force them to prove their case.
Yes, sir.
Okay? It's just that part of it will be completed.
Yes, sir.
Then we'll go to sentencing and have a chance to present some more testimony before the sentencing is occurred.
Yes, sir.
Okay? Very good. Based upon you doing this, entering into this freely and voluntarily?
Yes, sir.
You feel like you've had all your legal questions answered and this is
Yes,
in
sir.
your best interest to do it this way?
Yes, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea, free and voluntary, and we'll proceed to sentencing. And make sure the state to remind that after the sentencing that he's got 30 days to appeal it, but that would be after the sentencing, I believe, is when that triggers, correct, Mr. Swiatek?
Yes, Your Honor.
Anything further? Did I get everything, Mr. Swiatek?
Almost, Your Honor.
What did I get?
We will need a sentencing date.
We definitely need a sentencing date. And the reason why I didn't give you that is because we don't have that here. You're going to have to call my office because it's going to be in the afternoon of one of our miscellaneous days. If you call my office, I should get both of you on the phone. We'll get it done today if you want. It won't be done today. The date will be given to you.
And Your Honor, I do want to advise the court that I will be sending him to see Dr. Heather Holmes, who's a forensic psychologist that I've used before in this court.
Well, that's why it's important for you to get together with the state to figure out how far out and how long you're going to need and all that, and then call, and then we'll get it.
Yes, sir. Thank you.
But we'll do it as soon as possible after you get your, what, the state was asking who are you getting?
I didn't catch the name, Your Honor, of the,
Oh, Heather Holmes?
oh, thank you.
One.
Yeah, I do, thank you.
Okay. Thank you very much.
Thank you, John.
Mr. Swiatek.
Yes, sir.
Ms. Bostock, come here just for a second.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
I think that's your last one, Mr. Swanton?
Yes, Your Honor.
You have a great one. Thank you.
Thank you.
Mr. Powell, or you want to try and jump in?
Good morning, Judge.
Good morning.
Samuel Jones, 22 CF 2128. Mr. Jones is present, Judge.
Okay.
This case is Zach Rogers' case, so I'm not sure who's filling in for the state. We did get an amended offer this morning. I'm asking to leave this on for review,
Okay.
anticipating a possible plea to the court. And I don't, just for the states, I don't anticipate any trial, but if we could leave it on for review.
Your Honor, that was what I was expecting. We'll leave it on for Thursday morning, and I was asked to make the announcement that if a plea's not entered on Thursday, that the state will revoke the offer, and this will be a 10/20 life offense. So he needs, I just want him to understand that so that Mr. Powell can speak with him about what that means if we go to trial.
But you're anticipating at your review that there would be either an agreed upon plea or a plea to the bench?
Correct.
Is that what I understand?
That's correct.
Okay. So we're not going to continue it?
Well,
we're not, well, we would continue the sentencing, but if you plea to the bench,
right, well, yes.
I would accept the plea that day, and then we would schedule the sentence.
That's what I'm anticipating.
Okay.
And the information I have, Your Honor, the state is not anticipating a continuance. Either it will be a plea or...
Okay, very good. Okay, we'll see you this Thursday, 8/24.
Very good, Judge.
Thank you very much. You covering for any other...
Juan Carlos Bautista.
Juan Carlos Bautista.
22 CF 1075 and 1076.
Correct.
The state has filed an amended information, Judge. We're needing a continuance. They're not objecting. And it was set clear continuance.
So he's out of custody, so it will be 10/9 at 9 a.m. State okay, yes?
Yes, Your Honor.
Okay. Very good.
October 9th.
Yes, sir, October 9th, 9 a.m.
Thank you, Judge. That's all I
Thank
had.
you. Have a great day.
You too.
Thank you. Okay. Sorry for the interruption, Mr. Harper, but I think you're back up if you'd like to.
Judge, I can call my remaining out of custody Marlon Marshall, 48 on the docket.
Okay.
I've reached out to all the numbers that I have that were in our database. I have not had any contact with Mr. Marshall. We'd announced that on pre-trial conference that we're asking for him to be here in person since I have not had any contact with him. I have still not had any contact with him, Judge, and he is not present.
Judge, he was ordered to be here today. The state's going to request a capias.
Court will order and no bond capias.
The only case that I have outstanding is still Patricia Davis, but I think that's going to be covered by another attorney. I'll just stand by until she's addressed, Judge.
Do you have any? So, that, and all of them? Okay. Okay, very good. Thank you.
Your Honor,
Mr. Medina, you want to do a couple?
Yes, Your Honor, I have several out of custody ready to go.
Sure.
Some of them that states us probably signing the paperwork, but
Okay.
we can go ahead and get moving.
Well, we can do, and we can take a break too, because we're about approaching a morning break if you want to.
I think I can get at least 7 or 8 out pretty, without hesitation. But if the court wishes to take a break now, that's...
Yeah, why don't we take a morning break? If you're going to get 7 in, we'll come back and we'll get as many as we can in before.
Okay.
All rise, please.
The Cottage Formalwear, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalwear. We're located at 648 North Wilson Street. Call 850-682-2446.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just one block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roof.
Your Honor, I'd agree for Mr. Gates to go ahead and do these two continuances. I've got several pleas that'll take a little longer.
Okay, very good.
Yes, Your Honor. I see one in the courtroom right now, and I'll go ahead and take him. Diamond Henderson, Your Honor. Your Honor, this is Mr. Henderson at 23 CF 1254. The state and I left him in hopes we could get that restitution pinned down for a plea. Fortunately, we weren't able to. If we can move him to October the 9th, and then if we can get it resolved, we'll move him up for a plea, Your Honor.
Very good. We'll continue until October 9th at 9 a.m. Mr. Noakes, are you ready to go with a couple of years?
Yes, sir. Judge, the first case on the docket for me is James Casey. He was the gentleman that was not here for pretrial, and we left it set. My office contacted the bail bondsman, got a phone number, called Mr. Casey, and he was very, very nice to tell us that he knew to be in court this coming Monday already. But he's not here today, Judge.
Your Honor, the state would ask for capias.
They would issue no bond.
They asked if we could do Mr. Owens' email first.
Sure, that's fine.
Tricia Davis. And Mr. Owens.
Judge, I was contacted yesterday about Mr. Owens needing me to cover Patricia Davis. Currently, the attorney of record, I believe, is Mr. Harper, but Mr. Owens indicates to me that he's going to be getting in the case, and I believe that the client does not want the case continued. Is that my understanding?
Yeah.
Okay. So let's just leave it for jury review. I'm sorry?
Have you met with her attorney?
Judge, that I don't know. I mean, he's indicated to me that he's met with her, so.
Have you met with Mr. Owens?
I met with him a while back ago.
The reason why I'm saying that is that the jury review is only 4 days away. I don't mind continuing until then, but that doesn't sound like there's going to be much productive one. Is there a discussion going on with Mr. Owens about a potential plea arrangement?
No, Your Honor, there hasn't, and I don't think Mr. Owens has the discovery yet, because he hasn't filed a notice of appearance, so the state...
Okay, so here's what I'm going to do. I'm going to continue this until October 11th, the next regular cycle.
Thank you.
And if you can get some things arranged, first of all, we've got to get Mr. Owens to make a notice of appearance, but he's not even officially on the case. But if he meets with him, he wants to have a hearing before then and get a plea agreement or have something else, he can get it set. That's just the next regularly scheduled cycle. We have 2-month cycles. So and if you can get it done before something needs to be done, the court will be...
But we already set it for jury trial.
Man, nobody's ready for jury trial because he hasn't even gotten the discovery.
Rudy Harper set it for trial the other day.
But Rudy Harper isn't going to be on the case. Mr. Owens is. That's the problem. You got a new attorney. You got to get up to speed. These attorneys just don't roll in here and go to trial in these cases.
It takes a lot of preparation to go to a trial.
I can't get an earlier court date than October 11th. My feet are turning purple.
Explain it to her.
Judge, you're going to have to get with Mr. Owens.
Listen to me. If your attorney has something that he needs to bring before the court, have him communicate with the state attorney, and we'll get it set. How about that? Okay? But right now, the next cycle is October 11th. And no, there's nothing before then. Okay?
Right this way, Neil.
Thank you.
Judge, with respect to those cases, I'd like permission to withdraw.
Absolutely. Can you kind of
I'm going to take care of the judge.
make sure that Mr. Owens or somebody gets the paper?
I'm going he's in jury selection this morning. I'll text him and ask him to call me
That's
over
all
lunch.
right. Yeah, there's no problem.
Judge,
Hold on a second. Hold on a second.
Oh, I'm sorry.
There'll be substitution of counsel. We're announcing he's on. If there's something that happens, he doesn't come on, then we'll deal. Okay, I'm sorry, Mr. Novus.
Judge, this is Barry Gaspin.
Okay, very good.
Judge, he's got 3 cases on the docket, 21 CF 2971, 21 CF 3003, and 22 CF 2298. Judge, I met with him yesterday at the jail, and based upon the conversation that I had with him there yesterday, I immediately went to my office and filed a motion to withdraw.
Okay. And not to get into the weeds on the motion to withdraw, is there?
Judge, we've
I mean, are you private? Is this private?
No, it's not private. I was court appointed.
That's what I'm saying. You get a court appointed. Well, I guess we'll just deal with your motion. So we'll do a regular continuance, and then you can file your motion.
Judge, I filed the motion yesterday and noticed everybody with it.
Okay, I just haven't reviewed it.
I understand.
And Your Honor, for the record, any outstanding offers are hereby revoked in Mr. Gadsden's cases. And I can put the last one on the record if the court needs it.
Put it on the record.
Your Honor, the last one was on case number, do you have the case? It's 2971. There was a capital sex bat. The offer was an adjudication of guilt, 40 years DOC, followed by a remainder of his life on probation with an electronic monitor with no contact. The other 2 cases were to run concurrent with that. As I've already stated, as charged, he does face capital felony with a life without parole on just that case alone.
And Judge, as far as my motion to withdraw, I guess the court will just review that because I submitted proposed orders as well.
Okay.
To appoint somebody else.
Okay. It's a little different when you're court appointed, but yes, I mean, I just need to look at it if there's.
I don't know who next on the list is, but.
Okay. I'll review it. What's that? October 11th.
Judge, the next case I have is Mario Lee. The state provided me, I think Thursday, right after I left court, provided me some information that I had not had and had not seen. And I went to the jail on Friday and showed it to my client. Based on that, and they're tracking down some additional information to connect the dots to the FDLE report. As soon as they get me that additional information, I'm going to go to the jail and meet with him. So we do have depots set for November 17th. So we would ask this to be put on, I don't know when, October 11th ain't going to work because I think the depots are set for November 17th.
Well, I'm going to do it just on October 11th, just so we have a status, see how, if anything the court can assist, in getting things done.
Absolutely.
For instance, if the FDLE, we can push that a little bit and try and get that done.
Absolutely. Okay. Thank you, Judge.
Continue to October 11th. That's all you got?
That's all I got.
Thank you, Mr.
Unless you find something
You have
else.
a good day.
Judge, can I address one case?
Sure.
This is, he's not on today's docket, but he should be.
Oh, okay.
His name is Michael Bryant. Case number 23 CF 1225.
Hold on just a second.
He's not on the docket, Judge.
I know, I'm trying to find, okay. Bryant, and first name is Michael?
Yes, sir.
And what's the case number again?
Michael Gregory Bryant. It's 23 CF 1225.
You don't have to remember Mr. Medina?
Yes. No, I've got Michael Bryant. No, I don't have Michael Bryant.
Okay, Your Honor, I have Michael Bryant.
Oh, do you?
The public defender. I was talking to another client.
Okay. He's not on the docket today. Do you think he was supposed to be?
Yes, Your Honor. He came all the way down from Georgia to do his plea agreement.
Then we'll do it.
I apologize, it's the wrong Michael Bryant. It's
Hold
Michael
on.
Bryan.
Okay.
Brian,
Is yours on our docket, Mr. Medina, Mr. Bryant?
as far as I know, Michael Gregory Bryant, number 73 of the docket.
He's on the docket.
He's here for today, Your Honor.
Okay.
And we have the plea agreement for it.
And that will be taking place, so, okay, so what is yours, Mr. Hart?
I added a letter. It's Michael Stephen Bryan, which is 22 CF 655. We had set it for today, but he's not on the dockets.
Is he here?
There's a waiver, Judge, but yeah, it was moved to 10-9 for some reason. I don't know. Because we had set it in the minutes actually say today, but it wasn't on today. I didn't want him to fall through the cracks. I just wanted to officially address it.
Confirm that it was continued until October 11th?
And so-
9th.
Yes, sir.
11th or 9th? Inmate?
It's the 9th. He's out of custody.
Okay. So we'll just confirm that it was continued till October 9th.
Yes, sir. I apologize.
No, that's all right.
No, it's my fault. I may have heard Bryant, and
That's all right.
I did the same thing, so.
We are human.
Michael Bryan and Michael Bryant.
Well, they made the same mistake just a second ago, so don't feel bad. Okay. Mr. Medina, would you, Mr. Cobb, are you?
Sir,
Counsel, you want to?
Thank you, Judge, I appreciate it. I'm about to put my belt on. Judge, it's Michael Griffith representing Shamal Roach, that's R-O-A-C-H.
Okay.
And it is case number 22883, I believe.
That is correct.
Judge, I was contacted by Mr. Roach's mother this morning who advised he had COVID. I've asked her to send me proof of that, and I had not gotten it, and I had to leave Pensacola to get here before you finished up with court.
Sure.
So as soon as I get it, I'll file that with the court.
Okay.
I would ask, could we put this on your September 12th docket?
What is my September 12th docket?
Judge, that's a miscellaneous criminal day. The reason we're suggesting that is because we worked a plea in this case. We actually anticipated it being handled today, but for the defendant unfortunately being sick.
So, okay, so for a plea, so what do we have on September 12th? That shouldn't be a problem.
In the morning, you have 9.
September 12th at 9 a.m.
Thank you, Judge. And I may have another attorney covered because my wife told me I'm supposed to be out of town. And I'll get it
my
done.
My recommendation is that you follow the direction of your wife.
I try to, Judge. I appreciate it. Now have Mr. Roach here on the 12th of September.
Very good. Thank you.
Thank you, Your Honor. I appreciate your courtesy. May I approach the clerk for a moment?
Sure. Mr. Medina, you can go ahead.
May I proceed, Your Honor?
You may.
Sorry, Your Honor.
That's all right.
May I get David Tyrone Adams? Oh, there you are, sir. Mr. Adams is docket 59, and we have an agreement, Your Honor.
Okay.
And the state has a score sheet for David Adams. I'm just going to give probation an opportunity to, well, it's not going to be probation anymore. Never mind. May I approach her?
You may.
I think I have it on my phone.
Thank you. Do you have a score sheet?
Steve?
Yes, Your Honor.
Well, I'm looking for, Your Honor, I'm sorry.
That's all right. You can look through it while it's going.
I may have to print it out later, Your Honor.
That's fine.
He's familiar with it, but I'm just going to make
As
sure.
long as it's not a downward departure, if you can confirm that, then.
It is, I think, going to be a downward departure, Your Honor. I believe this is the.
Okay. Go ahead, Mr.
Yes, Your Honor, it is going to be a downward departure to 6 months. The state's lowest permissible guideline sentence under its score sheet was 14.4 months, but the state and the defendant have agreed to a 6-month deal.
And it's based on, the downward departure is based on?
Legitimate unforced plea bargain, Your Honor.
Very good.
And it was
A small amount of
Very small.
substance, Your Honor.
What's that?
It was a small amount of substance, Your Honor, and
Okay.
the charge which scores him for prison is from the 1990s, Your Honor.
Okay.
So,
Your Honor, under this agreement, Mr. Adams would be adjudicated guilty as charged. There would be 6 months Okaloosa County Jail with credit for all time served, and that's concurrent between the two charges. I didn't write the word concurrent in, as I probably should have. Does the court wish for me to add the word concurrent?
Yes.
I think it's understood.
Go ahead and.
Keep it out.
Finish it, and then
All right.
I'll.
Yes, Your Honor. Thank you.
Let you look at it. I mean, you can make a change when you get.
Yes, Your Honor. 615 court costs, 150 PD fees, monetary obligations to collections 12 months after release, and he would report for jail at the Crestview Jail by 5 p.m. tomorrow. That's August 22nd.
Very good. Just add that in.
Thank you, Your Honor.
Mr. Adams, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, you heard your attorney state, you can put your hand up. You heard your attorney state the terms of your plea agreement.
Yes, sir.
And those terms are contained in the written plea agreement that you signed, right?
Yes, sir.
Did you read that closely, that plea agreement?
Yes, sir.
And you went over it in detail with your attorney. Go ahead, Mr. Indeed.
I just added the word concurrent with an asterisk before the word jail.
You went over it in detail with your attorney to make sure you had all your legal questions answered. Importantly, you're waiving the right to go to a trial on this. You believe that's in your best interest? You understand that by entering this will be a final adjudication of your case?
Yes, sir.
Okay. Do you have any further questions regarding this plea agreement?
No, sir.
Okay, state is in agreement, correct?
yes, Your Honor, this is the state's
Okay,
agreement.
very good. Mr. Adams, based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt as charged on both counts, and you're sentenced to 6 months in the county jail. For each of those 2 counts, they'll be served concurrently at the same time. You will get credit for all time served on both counts. Standard fees and obligations that you'll have 12 months after your release in order to pay those before it goes to collections. You will not have to report to the county jail on or before 5 p.m. tomorrow.
Yes, sir.
Okay? Any questions?
No, sir.
Thank you.
Thank you, Your Honor. You got a draft. You got to go this evening. Your Honor, next will be Joseph Aaron Boone, 69 docket number. Mr. Boone is approaching in 22 CF 1886. Your Honor, the state and I, on behalf of Mr. Boone, negotiated what I thought was going to be an acceptable agreement based on the information I have from my client. Mr. Boone has decided he does not wish to accept the state's offer that I thought he was willing to accept, and I'm not here to pressure him to do it. It's his decision. He doesn't want to do it, but the state's not going to make it any better. There is a motion in limine that would need to get scheduled. It was the kind of thing that I would have anticipated would have been dealt with by jury review this Thursday, but I think the state has agreed we want to continue it, we'll set that motion in limine, so he'll have to come back on October 9th for pre-trial, I think, would be the next court date.
Your Honor, that's fine with the state. This case was set as plea or continue, so that's a reason for the continuance. I think we set it on the state to see if we could get that deal worked out, not on the state.
Okay. I did have it as a plea or continue, so we'll go ahead and do that. So we'll continue this till October 9th, 9 a.m.
Is the state willing to keep the agreement open, the potential agreement open until October 9th?
Yes.
Okay, so you can keep thinking about it just in case you change
And
your mind.
you'll go ahead and schedule up with my office for the motion in limine.
Yes, Your Honor, we will get a date together.
Okay, thank you.
Yes, Your Honor, thank you.
Thank you, sir.
Next will be Alonzo Borum. Mr. Borum is docket 70, case 22 CF 1169. Your Honor, I have advised Mr. Borum of the state's position that it would lower the total sentence points under an agreement were he to wish to enter such an agreement for a plea to the bench. That would be 60 points or lower. By the state's calculation would be 55.9 points, which would give him a shot to plead to the bench and ask for drug treatment. He's been accepted at Keaton. He also has potential for outpatient treatment in Atlanta, where he has good housing and jobs and so forth. I just need to get his decision on whether he wants to do that or it's going to be set for trial this cycle. He's been thinking about it, so. Your Honor, he's indicated he wants to do the plea to the bench agreement, so I'm going to write it up along the terms that the state said was acceptable. If you will allow us to bring him back in just a little while, we'll get it written up, and that will take him off the trial docket, and it can be set out for sentencing, Your Honor.
Very good. We're going to come back later this morning.
We're going to come back in a little bit this morning, ma'am. Your Honor, next is Mr. Michael Gregory Bryant with a T, docket 73.
Hold on just a second.
That's a 2. That's a copy for you. So that's your score.
You may. I'm sorry. Go ahead.
Your Honor, may I approach with Michael Gregory Bryant's agreement?
You may.
And the score sheet, Your Honor.
Thank you. You're okay with the score sheet?
Yes, Your Honor. Under the agreement that's been reached with the state, there would be a withhold of adjudication as charged. There would be 2 years probation, $515 court costs, $150 public defender fees, 50 hours community service, $3.99 cost of transportation to Okaloosa County Sheriff's Office. Maintain gainful employment or complete 2 applications per week. May seek transfer to Georgia pursuant to the Interstate Compact.
State?
Your Honor, that was the state's agreement.
Mr. Bryan, would you please raise your hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Okay. So you heard your attorney state the terms of your plea agreement.
Correct.
And those same terms are contained in the written plea agreement that I see you have signed. Have you read this plea agreement closely?
I have.
And have you gone over it in detail with your attorney to make sure you had all your legal questions answered?
I have.
You understand by entering into this, you're waiving the right to a trial. There'll be a withhold of adjudication, but this will be a final resolution of this case. Do you understand that?
Yes, sir.
I believe that's in your best interest.
Yes, sir.
Very good. Based upon that testimony, state's an agreement, right?
Yes.
Based upon state's agreement and your testimony, the court will accept this plea agreement. There'll be a withhold of adjudication as charged. The defendant will be sentenced to 2 years probation with the court costs. Standard court costs are contained in the plea agreement. In addition, there'll be 50 hours of community service, $3.99 cost of transportation for Okaloosa County, and you must maintain gainful employment or complete 2 applications a week, and you may seek transfer in Georgia pursuant to the Interstate Compact. It just requires you to file something. Generally pretty good about it, but I can't guarantee that.
Yes,
okay?
Sir. Yes, sir.
Any questions?
No, sir.
Okay, very good. Good luck.
Good luck. Get it to withhold so you don't reprint it. All right? Good luck to you. Thank you, sir. Your Honor, next is Corey L. Chavis. Mr. Chavis is docket 75 before the court at 23 CF 917. Oh, excuse me. 23 CF 655, docket 75. I may have looked on the wrong one. Sorry.
No, I got it. Thank you.
Your Honor, Mr. Chavis has decided, I've communicated to the state that he wishes to go to trial. It would be set next cycle, and in the interim, we will be taking the witness deposition that we tried to take before, but we think we now have a good address, so we'll be resetting her deposition.
So we'll come back, state, agreement, last continuance.
This is Corey Chavis. Yeah, this is the one, we took the victim deposition with Zach.
Your Honor, I think that this is okay to, I was just looking at the last continuance issue. I think that it will be okay to announce the last continuance.
Very good. So we'll continue this till October 9th, 9 a.m. next to pretrial. This will be the last continuance we anticipate, gearing up for trial next cycle.
Thank you, Your Honor.
Thank you.
Next is Mackenzie Eschke with an agreement, Your Honor.
How do you spell that?
ESHGHI, I think.
Got it. Thank you.
Your Honor, I need to make a copy of Miss Ed. No, actually, I think I can remember this. Your Honor, Miss Eschke is entering the pre-trial intervention program, and we have a PTI agreement that's been signed by the state. She's going to take a probation. The state is also requiring her to enter a plea to the court, and under the agreement, she would be completing the pre-trial intervention program. If she's successful, the case will be dismissed. If she's unsuccessful, the case shall go directly to sentencing. And it would be at the discretion of the court whether she would become a convicted felon. She has no priors. There are 5 felony charges here, so it's extremely important.
There's discretion if she fails.
If she fails.
PTI. No discretion now. It would be
Right,
dismissed if she completes it.
Exactly.
Just want to make sure she understands.
Yes, Your Honor. May I approach, Your Honor?
You may.
I have 6 charges.
Yes, one was a misdemeanor, ma'am. They're all being resolved through PTI.
That's right, possession of paraphernalia. Is the state in agreement?
Yes, Your Honor, that is the state's agreement.
How do you pronounce your last name, ma'am?
Eshke.
Eshke, like that? Eshke?
Eshke.
Eshke, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state, you can put your hand down, state the terms of your plea agreement. And this is a little bit of a unique agreement because you're entering into the pretrial intervention that would have a very favorable outcome if you complete it. There's no reason. I mean, you've gone over the terms of the PTI, right?
Yes, sir.
You understand that. There's nothing on there you can't do, right?
Yes, sir.
Okay. But if you succeed with that, these will actually be dismissed fully.
Yes, sir.
But if not, it'll basically be, you're pleading no contest, and the court would come back, would have the discretion to adjudicate you guilty or have a withhold. But, it could be a sentence. I mean, you've got you've got five felonies on here, 5. You know what the maximum for each of those felonies is?
Yes, sir.
5. What's 5 times 5? 25. That's your max. That's your upper limit. That's not even counting position of paraphernalia. The one point I'm saying is that when you get up in the morning, first thing you need to be thinking about is how you're going to complete that PTI in time. That needs to be doesn't need to be your second priority for the next 3, 4, 6 months in order to get this done.
Yes, sir.
I'm just saying this to you because unfortunately, even today, I've had several PTIs that came back here. I want you to be successful. You better take this seriously, dead seriously, or this could end up very badly for you. That's what I'm saying. This is a tricky plea agreement because it's very positive on one side, if you get it, but if not, you can't object at that time. And so I didn't mean to enter into that. Let's go to a trial on it. You're waiving. You understand you're waiving the right to go to a trial on it.
Yes,
You
sir.
understand that? And that's a big right. Okay. And you believe this is in your best interest to enter into this plea agreement?
Yes, sir.
You've had all your, I didn't raise any legal questions that you need to talk to your attorney about?
No, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea agreement and you will proceed with the pretrial intervention, hopefully successfully, and these will be dismissed. If not, we'll come back on sentencing. Okay?
Yes, sir.
Okay. Thank you very much. Good luck. Question, Mr. Medina? You look puzzled.
Oh, no, I'm just being puzzled for later in the morning.
Okay, thank you.
Thank you. Good luck. You're taking that, you're going to see them, they're going to tell you where you go to meet with your PTI officer at state probation. Good luck. Thank you. And her grandmother is present with her, with whom she lives, Your Honor.
Okay.
Your Honor, next is Alexander Robert Etheridge. Mr. Etheridge is number 84 on the docket. He's before the court in 22 CF 1899, which, by the way, was a PTI agreement that he failed to complete, to make the point on that. And then the other case is 23 CF 574. And if I may approach with the agreement, does they have the score sheet?
Yes.
Just making sure he sees the score sheet. Approaching, Your Honor, if I may.
You may. Thank you. There's a score sheet?
Yes, Your Honor, that's under there, I hope.
Hidden under there. There you go. Thank you. And you're in agreement?
Yes, Your Honor.
Go ahead.
Your Honor, under this agreement, Mr. Etheridge will be entering a plea of no contest in both cases. And as I stated, 22 CF 1899 was a PTI that he failed to complete. Sadly, the second case occurred within about a week of it. It was right before Christmas, and there were some difficult circumstances, but nevertheless, he picked up this other case, and the state was not willing to reinstate the PTI agreement to encompass the second case. There would be a withhold of adjudication, and that's as stated above. 22 CF 1899 had already been reduced to a lesser included offense, third-degree felony. It had been originally charged as a higher level. So he would be getting a withhold of adjudication as to the lesser included offense, sale or delivery of cannabis that was already part of the PTI agreement. And in the other case, it's as charged in the information. And there would be 2 years concurrent probation on felonies, 11 months, 29 days concurrent probation on misdemeanor, and that was the petty theft in 23 CF 574.
So it's a total of 2 years?
Total of 2 years
They're all running concurrent, right?
Yes, Your Honor.
Okay.
464 restitution to Party City, which was the victim in 23 CF 574. $1,140 court costs in 22 CF 1899. 515 court costs in 23 CF 574. 250 public defender fees, substance abuse evaluation within 30 days with any recommended treatment to commence within 60 days. 50 hours community service. No contact with Madam Clerk. There are 5 sets of initials. If the court will permit, I won't state them all, but they are in the agreement. No trespassing at Niceville High School, which was the alleged location of the charge that he pled out in 22 CF 1899, or at Party City, which was the location in 23 CF 574. Maintain gainful employment or complete 2 applications a week. Anti-theft course. And I understand, I mean, you're 19 years old, is that right? Are you 20 now?
I'm 19.
19. He's 19, he's working 2 jobs. The state has agreed, because the court costs are so high and so forth, that there would be a waiver of cost of supervision, and that he can do community service for eligible costs. Madam Clerk, I'm not sure exactly how much would be eligible, but I know he is going to have to pay some monetary amount, and I think probation can work with him on that. Your Honor, I think that's the agreement, Your Honor.
State.
That is the state's agreement.
Mr. Etheridge, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Okay, so you heard your attorney state the terms of your plea agreement, correct?
Yes, sir.
And those same terms are in detail laid out in your plea and sentencing agreement. Did you read this plea and sentence? I see you've signed it. Did you read it closely?
Yes, sir.
And did you go over it in detail with your attorney to make sure you understand all the legal implications of this?
Yes, sir.
And you understand that by entering into this plea agreement, you're waiving the right to go to a trial. This will be a final resolution of this case. Do you understand that?
Yes, sir.
So, you've been on PTI, and you're now being placed on probation. You need to hang around here a little bit today and see some of the guys in the orange. That's what's going to happen to you if you come in and violate this probation. Time for you to grow up. You got a lot of details in here. And what I said to the young lady previously, I say to you, this needs to be, when you wake up in the morning, you need to say, what do I need to do on my probation? It needs to be number 1 on your priority list, not number 2 or 3 and push down to the side and wait till the last minute. You do that, you're liable to spend some time in jail. Now, I don't want you to be successful. I'm saying this to you because you are 19 years old or 20. You're a young man. You better get this right, or you're gonna be spending some time in jail. Okay?
Yes, sir.
But based upon your testimony, your understanding, your discussion with your attorney, the court will accept your plea agreement. There'll be a withhold of adjudication, 2 years of probation, regular probation on the felonies. There'll be concurrent, and then 11 months, 29 days probation on the misdemeanor. They'll basically all be served at the same time. So you a total of 2 years. You got the substance abuse evaluation, that's important. And trust me, there's no contact with these individuals. I assume they're initial because they're juveniles. And no trespassing at Party City or Niceville. Don't fool around with that. If that's violated, they will pull this probation on you in a New York second. Okay?
Yes, sir.
So, any questions?
No, sir.
Thank you.
Thank you.
Go talk to the probation.
Your Honor, I've got a couple more that I'm ready to call, and then I need to kind of regroup with some
That's fine.
people who've shown
That's
up. Your Honor, next is Mary Nell Mason, docket 8621 CF 2586. Ms. Mason is approaching.
Sir?
Ma'am?
Sir,
Oh, yes, ma'am.
I don't want to use my attorney. I want to fire him for ineffective counsel.
Your Honor,
Okay.
Your Honor, may it please the court, we've been before the court 3 or 4 times, and I've reported the status. She does not wish to take the PTI offer. The state has indicated it is going to revoke the PTI offer. I certainly highly recommend that she take it, and she has indicated various times in the past before the court that she was unsatisfied with my counsel, but she has not filed a Nelson motion, and so that's not before the court. So I am
Okay,
her
so
lawyer.
here's what we're going to do. Okay. If you don't want your attorney, you need to file something. Do you understand that?
Yes, sir. I did look up on the line this whole weekend, and it said all I had to do was let you know. It didn't say nothing else. So,
Well, I'm telling you something different. You need to write it down so that I can put it back on, make a hearing on it.
Yes, sir.
Okay, we'll continue this. That's fine, but this,
Your
so you're, I just want to get this straight. You've been offered a pretrial intervention in which all this case would be dismissed if you completed, and you don't want any of that.
That's not it, sir. That's not it. What they promised me was different than what they handed me on the paper. And so.
But what you're doing is you're throwing the baby out with the bathwater. You ought to get the PTI straightened out, because he's about ready to revoke this thing,
I want him to.
and you're going to be at risk for
I'll go to jail.
5.
I know it.
5 years in DOC.
Yes, sir. I know that.
Your Honor,
But I'd rather put me in jail than have him put me in jail.
Your Honor, certainly.
I don't want to put anybody in jail if they don't need to be.
I don't want to either.
But if
But I
you
am
keep
saying
fooling
I don't
around,
have
I'll be putting you in
adequate
jail.
Representation.
Your Honor, can
I am. Would you mind if I say one more thing?
No. Why don't you let him talk for a second?
Okay.
Go ahead.
Thank you, Your Honor. I just wanted the court to be aware that this was set for plea or trial.
I understand.
And,
We're not going to force you to go.
With respect to those types of issues, that she's dissatisfied for various reasons that I haven't pursued a motion to suppress. I haven't filed one nor pursued
Ms. Medina, whatever reason she puts in her, just wait, I'm going to forget until we come to the hearing.
I'm only raising it because it has to do with the nature of what I believe the state is going to. Go ahead. You want to state your position.
Well, Judge, I was going to say that I have sent out my subpoenas. I was preparing for trial. I believe that 2 of my 3 witnesses are available. FDLE, I'm waiting on the analyst. I would like to soft set this for Thursday. I was not expecting what has also occurred here today, so I will defer to the court. But I'd like to bring this in for a landing. It's an old case. It's rusty.
I'd like to bring it in for a landing too, but if she's complaining about her attorney, she has a right to file something. And of course, she hasn't filed it. She's just gotten bad advice that she could just announce it in open court, and that would suffice. But I don't see what I can do. I mean, if she goes to, she can't go to jury trial with no defense attorney.
I understand.
Well, she might if she fires him for not good reason, but I'll explain that to her when we go to a hearing.
Yes, Judge. And just for the record,
And I'd like to have it ready for trial too. I mean, I don't like sitting on it. You know, we're trying to move these cases and get a resolution, but I think my hands are tied.
Your Honor, for the record, the court advised her on the record, I think 2 court appearances ago, if she wanted to pursue a Nelson motion, to file a Nelson motion. So she did not follow.
So you want me to proceed to trial?
I'm here as an officer of the court to do whatever the court says, but she
So
was
what you're saying is that she was previously advised.
I don't know
So
what
you were previously advised to
Yes,
file
sir, but I'm
something?
not an attorney. I don't know how to do a Nelson. I looked it up, and there is no there's no form, thing to do it in. So I'm at loss to how to do it. I did try, and I am trying to obtain new attorney,
And we said that.
which would be Mr. Joseph Bodine. No, okay, whatever. The one in Tallahassee. I've been talking with him all weekend. And him or as one of his representatives, I'm hoping will help me to finish this out. Bodiford.
So is that private counsel?
Yes, sir, that's who I'm trying to get as counsel.
Okay. So
He's got
have you retained them, or are you?
Well, I have talked to him. He asked me to send him the paperwork so he could look it over. I did that, and that was Saturday morning. And I'm supposed to hear from him today. I've already sent him another text during the break, letting him know what has transpired up until now.
Maybe he's ready for trial. We'll come back on jury review.
Thank you.
That's on Thursday of this week, Your Honor.
8/24.
Jesus Christ. Okay, thank you. And do I have until Thursday to put in this Nelson paperwork?
It needs to be filed before then so that
That's what I
the
said.
court
So
and
the
the
court
parties can see
I
it.
can address it then. It needs to be done before then.
Judge, is this set plea continue for 8/24? Because if not, then I'll file my motion on me.
File your motion in limine.
Yes, sir.
Let's see where this thing goes. Maybe she'll
Your
show
Honor,
up on Thursday with a new attorney.
That's what I was trying to talk about, the suppression. The motion in limine that would be coming up relates to keeping out complaints about the nature of the stop, the nature of the canine. In other words, what she contends were suppression type issues that should have been pursued. I did not, in good faith, believe that I had a sound basis for motion to suppress, or I would have brought one up. So the state's motion in limine is making it clear that the case is only about did she knowingly possess the alleged contraband. It's not about was it a valid stop and so forth. And she disagrees with that limitation, which will be the subject of the motion in limine. So it all goes together.
Right. My understanding is the defendant wants to go to trial and talk about dog sniffs, and that's not a relevant issue for trial.
Okay. Well, let's see where we go on
I
jury
have a
review.
motion to suppress, Your Honor.
I'm
And
sorry?
my first attorney. I have a motion to suppress from my first attorney. I have it with me if you'd like to look at it.
I did not have a good faith basis for filing the motion to suppress that a prior lawyer had filed. I did my homework.
You didn't.
Ma'am,
I'm sorry.
you need to get yourself an attorney you feel
I'm
comfortable
trying.
with.
I am
Well,
trying, sir.
don't try. Get it
I
done.
will. I will have one.
'Cause if not, you're going to be going to trial without an attorney.
Thank you.
That's
Thank
not a
you.
very good place to be. And file something. File
I'll have one
Nelson.
tomorrow morning. Sir.
File in a piece of paper. File and put the case number on it and say what you want to say. And
Yes, sir.
because you're
Before the
a
next
pro
day.
se client, both can't talk at the same time.
I'm sorry.
We're recording this and it doesn't pick it up.
Excuse me.
Okay.
Your Honor, I'll be happy to give her a pad and pen if she wants to write it up by hand.
I've got one.
Okay. Thank you.
Your Honor, next is, yes, ma'am.
You're through.
Thank you.
Till
you.
Till the 24th at 9 a.m., ma'am. Next is Tyler Merritt in docket 87, 21 CF 2937 and 22 CF 2894. I do know he's wearing shorts. I asked the court, I'm not sure he realized that you can't wear shorts to court. Okay. Your Honor, I'm asking to continue these cases. The state, I think, might have some status information. We were trying to obtain the FDLE in 21 CF 2937, and there was also a federal search warrant that needed to be produced. I don't know if the state has any information.
Your Honor, Mr. Medina reminded me that that was still an outstanding issue, and I am working on getting that for him. We did send some amended discovery that had some issues to do with the other case, and I apologize to him. I thought that that had been sent with it. I reached out to try to get a copy of those things, and I will keep him updated as soon as I get it.
So continue to the next cycle, October 9th?
Yes, Your Honor.
Very good. October 9th at 9 a.m. Stay in
And
touch with your attorney.
I'll discuss with some other clients their situation, Your Honor. Thank you.
Okay, very good. Mr. Gates, are you finished for this morning or for a little bit?
I have several out of custody and then many in custody.
I understand that, but I'm just saying, I'm just trying to figure out what we're doing here between now and the next.
Mr. Gates is ready with this.
Okay, I didn't know if you were kind of a good time to pause for yours and go to Mr. Gates?
Yes, sir. It is a good time to go to Mr. Gates.
Okay,
Yes,
that's what I was just trying
yes,
to.
I'm sorry, Judge.
That's all right.
A little slow on the uptake here.
Who you call first?
Your Honor, I'll take my out of custody, Mr. Martez Jones.
Mr. Jones, if you'll come forward.
And then I'm ready for however the court security wants to run the inmates. Your Honor, this is Mr. Jones before the court, 22 CF 2729. The state and I spoke about his case this morning. They're still trying to get restitution together. We do have a plea agreement. In principle worked out. We just need to get the restitution out. If we can set him for October the 9th, Your Honor.
Okay. Very good. We'll continue this till October the 9th for a plea.
Mr. German?
This is Mr. Giovanni German before the court, 23 CF 776. We had left him today as a status. The state and I briefly discussed his case. We are at this time going to ask the court to set Mr. German for October the 11th. The state and I also talked about the bond revocation in this case. It was based upon an arrest warrant that was served on him. The state, after looking at the PC in that case, has agreed to reinstate the bond in this case. I will be following up with an order later today, essentially with a stipulation to reinstate the bond on this one.
Would that allow him to immediately get out?
He would have to postpone on the other case. I can't help him on that one, but this would at least on this one, he could bond out.
The reason why I'm saying that, if it would allow him to get out, then I would ask to follow up with my judicial assistant to make sure I sign it today so you can get out. I don't want him to be in jail tonight if he can get out because I didn't sign something.
Yes, sir. And what we can do is I can do that, but I think the court could also put on the minutes to be released on the minutes as well. We've done that before. Madam Clerk will just notate the reinstate the bond of this.
That's true. So we're reinstating the bond. What do you want to tell the amount, or do we care?
Well, I think we'll follow up the paperwork, Judge.
Okay.
But
So reinstating the bond on what? Which
23
case?
CF 776.
Okay, very good. So we're reinstating the bond. The minutes would reflect.
But for the record, I do agree with his characterization. And
sure.
That's correct.
Okay, well, I appreciate it, John. I assume that, but I shouldn't assume that.
We'll set him for October the 9th, Your Honor. The intent is for him to be out instead of the 11th.
So, October 9th?
Yes, sir.
Okay, October 9th.
Wayne Hall.
There's Mr. Hall coming up. Actually, I have a plea agreement to be filed for Mr. Hall. Told him we would hopefully get him done before lunch, and it looks like we're going to be able to do that. We have a plea agreement to be filed in Mr. Hall's case, Your Honor, if I may approach.
You may.
There is a score sheet attached. It does show 13.9 months DOC. No objection to that, Your Honor.
Very good.
The state incorporates Mr. Hall receiving time served from time spent in DOC. You got some better shoes?
I'm in bed. You know I got prison clothes.
Okay.
You know what I got. Honestly, let me wear my Crocs. That's all I got.
Counsel, you may. I'm sorry.
Yes, sir.
You may proceed.
You got to send Mr. Hall before the court in 21 CF 2317, State of Florida versus Wayne Hall. This time we'll be entering a plea of no contest as charged. We adjudicated guilty in counts 1 and 3, which are the felony counts. Will be sentenced to 13.9 months Department of Corrections that are concurrent with credit for all time served, including any previous time spent in DOC. The state has graciously agreed to give him credit for the time he's been in, which is more than 13.9 months DOC, and have agreed that he does not need to be transported to DOC and be eligible for immediate release today. Standard court cost, time served in the second count, we'd ask the court to send those outstanding costs to elections.
State.
That's correct.
Very good. Mr. Hall, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I swear.
So, you heard your attorney state the terms of the plea agreement, and obviously, good agreement for you. And it's in writing on the plea agreement you signed. Just want to make sure you understand what you're doing. You've read the plea agreement, gone over with your attorney. You understand, you believe that's in your best interest to enter into this today?
Yes.
You understand this will be a final resolution of all your cases?
Yes.
No more probation. You've already served the time. There are some fees and costs, and they'll go to collections. Nobody's going to pick you up because you didn't pay them, but it will go to collection. You'll deal with that later.
Thank you.
Okay, do you understand it? Now, let me ask you this. Would it be helpful to, rather than sending them to collections now, to give them 6 months or something to pay those before it goes to collection? Would that be?
Your Honor, Mr. Hall has just spent, I want to say roughly almost 2 years in prison from a previous sentence. I think those were sent to collections. His intent really is just to be done with everything and get back to Atlanta just as soon as he can.
Okay, very good. Okay, based upon that testimony and the plea agreement, the court will accept your plea agreement. There'll be an adjudication of guilt on all 3. Credit for time served in second count, which is the misdemeanor. The 2 felonies sentenced to 13.9 months in DOC. They'll be concurrent. You'll get credit for all time served, and the state specifically agrees in the agreement that the defendant has served more than the 13.9 months. You will not need to be transported to DOC. You're going to be eligible for immediate release. And there'll be fees and court costs that will go to collection. Any questions?
No, sir.
Good luck.
Thank you.
Right this way, Mr. Hall.
Look, so. Your Honor, next I've got is going to be Marcus Thompson, Your Honor. Mr. Thompson and I just met last week, and we sent over a counteroffer to the state to incorporate cases before the court. The state has asked that we can leave Mr. Thompson's plea continue for Thursday. The hope is that we can get this resolved on Thursday.
Very good. We'll continue this to jury review 8/24 for hopefully plea or continue.
Your Honor, this is Mr. Ricky Wilson before the court. He's before the court in 21 CF 143, 21 CF 534, 21 CF 553. If I can just put on the record, this morning I spoke with Mr. Wilson and the state this morning. Mr. Wilson has been asking me, and I want to make sure the record's reflected here, that I've asked the state to consider something less than the guideline offer of 11.65 years. Mr. Wilson has asked for a DOC sentence.
11.65 years or months?
11.65 years, Your Honor. Mr. Wilson has asked the state would consider something in the 9 to 10 year range. Does the state have a response?
The state's response to that request is no. The state worked on agreeing to dismiss some charges and reducing some charges to get to the 11-year agreement, Your Honor. And that 11-year agreement was made because I understood that Mr. Gates was previously made an offer in a range, but not a firm offer. Just to put on the record, Your Honor, if this was my case from the beginning, I would have made a higher offer. However, because Mr. Gates has a good reputation, and I did see notes that he did receive that offer, I wanted to honor what Mr. Gates had previously been told the state would do. The state is unwilling to reduce any more charges or get rid of any more charges, so the state's offer is 11 years and 0.65 months.
Okay, I think that's clear.
Yes, Your Honor.
So where are we at? Sorry.
I have to leave it to Mr. Wilson. Do you want to think about it some more and come talk to me, or you made your decision? Not taking it. Your Honor, if we could, the record could reflect that Mr. Wilson is rejecting the state's offer. The state and I had talked about this case over the weekend. As I told the court last week, I was fairly sure I was not going to be prepared for trial this cycle. I think I told the court I'm going to make sure I did it correctly. If we could continue the case, my intent is to have 21 CF 143 set for trial next cycle. I think the state is in agreement with that as well.
Yes.
Which one?
21 CF 143.
The state's intent is to go to trial next cycle on that 25-year Minuteman case.
And I will be more than prepared. One of the big issues, Your Honor, is there's some potential motion on minays I want to try and get filed. Obviously, the court's seen me more than I prefer to be in court lately, so I just have not had a chance to review all that and get those filed. This extra time would give me a chance to get those filed, get those set, heard, and prepare any potential defenses we might have.
Okay. And what are the maximum sentences on these charges?
Give me just a second, Your Honor, and I will make sure I get this
I'm sure
correct.
the defendant is aware of it, but I
Yes,
just want to
Your
make sure I understand what the...
Prudent, I think. So, Your Honor, you want to know about the 21 CF?
All of them.
So, Your Honor, in 21 CF 143, Mr. Wilson, the maximum sentence on count 1, the trafficking in illegal drugs, heroin 28 grams or more, but less than 30 kilograms. You do believe that that is 25 years, is that 25-year minimum mandatory, Your Honor? The second charge is a third-degree level 3 possession of a controlled substance. That maximum sentence is 5 years. Your Honor, the third count is driving while in habitual traffic offender status. That is a third-degree felony level 1. Its maximum is 5 years. Your Honor, the N21 CF 534, Mr. Wilson is charged in count 1 with manslaughter, Your Honor. That maximum, I do believe, is 15 years, Mr. Gates. That's the second.
It is, Your Honor.
And then the second-degree felony, the second count is some manufacture deliver, Your Honor. That is a second-degree felony level 5 offense. That counts maximum is 15 years. And in 21 CF 553, In count 1, Mr. Wilson is charged with trafficking in heroin, 4 grams or more but less than 14. That is the 3-year minimum mandatory, Your Honor. The maximum on that count would be 15 years. The second count is another driving while in HTO status. That counts maximum is 5 years. Count 3 is burglary of an occupied dwelling. That's a 2nd degree felony level 7. That is a 15-year maximum count. Count 4 is petty theft. That counts maximum is 1 year. Count 6, Your Honor, is resisting an officer without violence. That's a misdemeanor in the 1st degree. Its maximum is 1 year.
What about the fleeing and eluding, Leo?
Rough ballpark, Your Honor, I had it about 127 years, give or take a year for a misdemeanor. If the court was to, if he was found guilty as charged on all counts, and the court was to sentence him consecutive on everything.
Okay. So, Mr. Wilson, I assume you were aware of all that. Okay. Let's load them up. We'll do it.
Yes, Your Honor. And set it for October the 11th for pre-trial.
October 11th, and let the record reflect last. And this, based on the age and the severity of these
Yes, Your Honor.
Yes, Your Honor.
crimes, and not only what's going to be tried, but what is also out there. This will be a priority for the next cycle.
Your Honor, just for the record, I think it's obvious, and I think Mr. Gates has talked to his client about this, but that 11-year offer is now revoked.
Very good. Thank you.
Right this way, sir.
Thank you, Your Honor. That's all I have, Your Honor.
Yeah, this is probably a good time, unless Mr. Medina wants to do 1 or 2 more.
I can do 2, Your Honor.
Other than that, we can.
I have 2 others that I'm sure the state will let me take, Your Honor. Your Honor, Jonathan Knight, is there a Jonathan Knight in court? We left him in order to status to see if we could figure whether he was incarcerated or not.
Judge, I did some homework on this case. I did call Swainsboro County to see if he was in their jail. I spoke with the prosecutor's office. They confirmed that he is not in their jail. At this time,
Is this on? Oh, there it is. I'm sorry.
At this time, we don't know where he is, so I'm requesting a KPS.
We've already gotten that too. He's got to have to keep his son this week.
Yeah, 2.
Yes, Your Honor.
Should. KPS.
And the last one I've got on the docket this morning, Your Honor, is going to be Danielle Tankersley. We left her as a status. The state and I are still trying to work out the terms on this. She's currently in DOC custody. If we can continue her to October the 11th date, Your Honor, my anticipation is we should be able to get a result.
State.
I would agree with that.
Very good. We'll continue that until October 11th, 9 a.m.
It's all my business before
we
the board.
We'll take our midday break. We will reconvene at 1:30.
Thank you.
Thank you very much.
All rise, please.
Thank you.
Your Honor, I'm terribly sorry. I just had a